Greetings and welcome to a very special Leaflet interview. My name is Akriti, and as 2023 draws to a close, we find ourselves examining a wall that separates the center and the states. The wall of federalism has less bricks in it at the end of 2023 than it did at the beginning of the year. Guiding us through this very complex landscape of India's asymmetric federalism, we have with us Mr. P.D.T. Achary, a distinguished figure in the Indian political discourse and a constitutional expert. Thank you for being with us, sir, here today.
Thank you.
With his vast experience as the former Secretary General of the Lok Sabha and author of insightful books such as Resurgent India and Law of Elections, he brings a wealth of knowledge and wisdom to our conversation today. Thank you for being here once again, sir.
Thank you.
So to begin this, sir, what are some of your takeaways on the general state of affairs of federalism in India this year?
Well, Dr. Ambedkar had said that our constitution is federal when there is normalcy everywhere, but it is unitary in times of emergency. So this is an apt description of the Indian federalism. And so you can understand what exactly is the state of federalism in our country. After 75 years, we know what condition the federalism is in. But it is a very interesting issue, how federalism has worked and what exactly is the nature and character of federalism which our constitution has designed. India, of course, is a federal country. That is what everybody says. But it is not a federal country like United States and so on. We are a federal country because of the division of legislative power between the union and the states.
Right.
That is the main feature of Indian federalism. Otherwise, Indian federalism, of course, has been variously described as federalism with strong unitary features and amphibian and this and that. The point is that India does not fit into the classical federalism mold.
Definition, right.
And we have very strong unitary features, and that is understandable because when the country became independent, there was a lot of bloodshed here because of partition, and there was instability and all that, and a very uncertain future was staring us in the face. So naturally, the framers of the constitution had the unity of the country in mind, because over everything, unity had precedence over everything. After all, the country has to remain united.
Yes, absolutely.
That was the overriding concern of the constitution makers, and that is why, although they have certainly crafted a kind of federalism, as it was thought that federalism was most suited to this country because of the diversity that exists in this country. Still, we must have a strong center, and only a strong center can hold the country together. So this was the major consideration in the minds of the constitution makers when they crafted or designed this kind of a federalism. Otherwise, as you know, that in classical federalism, the states units, they are more important. They come together and they arrive at an agreement, and the federal government is created by the states.
Right.
But here it is just the other way around. Here, the center was there, and the central authority created these states, the federal units. So that is very interesting.
Yeah, right, sir.
But then, in a classical federal system, the residuary powers are vested in the states. But here it is not so. It is actually vested in the residuary powers are vested in the union.
Right.
That is how we have designed it. And of course, as I explained at the beginning, for obvious reasons. But even otherwise, of course, Ambedkar had said in times of emergency, it will acquire a unitary character. Now, even otherwise, even in normal times, if you look at the provisions of the Constitution, which relate to this federalism, you will find that there are many articles, through which the union government can control the states, even in normal times. Now, for example, Article 3, just take Article 3.
Yes, sir.
Which gives enormous powers to Parliament to redraw the boundaries of a state, amalgamate two states or two or three states, create new states or union territories, and so on. Change the name of the state, and then all these kind of changes can be brought about through a law by the Parliament. So Parliament has been given this power to redraw the boundaries of the state, change the shape of the state, diminish the area, increase the area, and all that. So this can happen only in a unitary state, in fact. It cannot happen in a federal state. Then, when you come to Article 254.
Right, sir.
254 says that if there is a clash between the union law and the state law on a concurrent subject, then the union law will prevail if there is a conflict. That is repugnancy. Okay. But apart from that, the most serious inroads into the state's power is the proviso which has been given there, which says that Parliament can repeal a state law.
Right.
Parliament can, in fact, repeal a state law on this concurrent subject. So that is the extent of power that has been given to the union. Then you come to Article 256 and 57.
Of course.
Now, 256 says that the executive power of the state shall be used so that the union law is implemented in full, and
Yes.
the central government can issue directions to the states for this purpose. Central government issuing directions to the states to act in a particular manner, that goes against federalism, actually.
Federalism, the essence of federalism.
Then Article 257, there, in fact, the union can issue directions directing the states to exercise their executive power so as not to impede the exercise of the executive power of the union.
Right.
It's kind of, these are some of the provisions which are there, which can be used in the normal times.
Not in an emergency, but in regular course of action, yes.
Of course, in an emergency, certainly the Parliament has the power to legislate on any subject, state subject or central subject or concurrent subject or whatever that is there. And then the union can, the president can impose an emergency, a financial emergency.
Right.
That is also there, very drastically curtailing the powers of the state in the matter of finance, financial management of the state, and so on.
Right.
Then, I was referring to Article 256 and 57, where the union government has the power to issue directions to the states.
So you're on mute for a second. I'm so sorry. Yes, sir.
If a state government refuses or defies the direction of the state or the union, then the president can conclude that a situation has arisen where the government of the state cannot be carried on in
Right.
accordance with the provisions of the Constitution, and then Article 356 comes into operation. So
In
this
that
is what
state.
it is. So these are some of the provisions which are there in the Constitution, which make inroads into a federal system. They're saying. So even in normal times, this Constitution has a tendency to usurp the powers of the state,
Of the state.
although it is called a federal country or federal constitution, but federalism mainly because of the division of legislative power.
Right,
That
sir.
is that is the only major feature of Indian federalism. Otherwise, it has very strong unitary
Unitary. So
features.
have we deviated from what Dr. Ambedkar originally envisioned for us? Or since he said it's unitary in the times of emergency, but or was it always like that and we just, I mean, did not acknowledge it?
No. Apart from what he said, he was
Right,
talking
sir.
about the emergency situation where the country becomes unitary in nature.
Yes.
But what I'm saying is that even in normal times,
It is
the
a
parliament,
unitary
the
federalism.
union has enormous powers to take away the powers of the state and thereby weaken the federal system.
I understand that, sir. And that's thank you for saying that because that has been the basis of our conversation, this had formed the basis, and we will be delving into the specifics of Article 3 as well as 256 and 356. So let's begin with what has happened in Delhi, essentially, sir. With that one would call it a flashpoint in the federal conflict this year. So May 11th was a historic day as the Supreme Court delivered two judgments, one on the GNCTD Act, the other on the Maharashtra issue.
The first judgment of the Supreme Court, I mean, uh, on the issue of services,
When the
uh,
notification was challenged, sir. Yes.
yeah, the services were transferred to the central government through a notification, which was challenged by the government.
Right,
And the
sir.
Supreme Court had given a very classic judgment,
Yes.
in favor of the state. And they said, this is a subject which belongs to the state, and certainly it is state which has the authority or control over that subject.
Right.
But immediately after that, within 2 weeks, I think, the central government has issued an ordinance
Yes.
taking away that power. And I had written about it at that time,
Yes,
and
sir.
I had said that the the union government cannot nullify a Supreme Court verdict on an issue unless, of course, they change the basis of that judgment.
Right.
Supreme Court had made it very clear in many judgments that you can change the basis of our judgment, but you cannot say that our judgment is wrong and it should not be adhered to or
Followed.
should
Yes.
not be obeyed. And you cannot nullify the Supreme Court order because you don't have judicial powers. Union government or parliament does not have judicial powers.
Right. Absolutely.
Now, after that, when they brought the bill, and of course, in my article, I had particularly referred to a section in that ordinance. But when the bill was brought,
Yes.
that particular section was deleted.
Yes. Yes.
Um,
That was my
now,
next question, sir, in fact.
this issue is now before the Supreme Court. They have not. I think the Supreme Court has not set the date for hearing on this issue.
Yes. Yes.
Therefore, it is hanging fire. It is just in Trishanku, the whole issue. But the Supreme, I mean, the union government in the meantime has enforced the law. So under this law, the status quo ante has been restored. I mean, the union government has kept the services with them now.
Yes.
Now, one point which I wanted to mention here is one important point. When the bill was moved in the Lok Sabha, the Home Minister had said that Parliament can make any law on any subject, so far as the union territory is concerned. That's quite okay. As a general statement of law based on the Constitution, that was okay.
Right.
Parliament has that overriding powers. I have already explained that in the beginning. But here, there is a difference.
Hmm.
The difference is that under 239 AA 7, Parliament has been given power to supplement the constitutional provisions, to supplement the provisions contained in Article 239 AA,
Yes, sir.
which governs Delhi. Now, what is the difference? Parliament has been given the power to supplement the provisions of the Constitution. You cannot supplant this.
Supplant.
You can't change the basic character of these provisions. You
Right,
cannot
sir.
go against the provisions. So here, it is not the general proposition which is applicable. That is, Parliament can make a law overriding or repealing or amending or any law that is made by the state, in this particular case, the Union Territory.
Right, sir.
That is not what is applicable here. What is applicable here is the law which Parliament will make amending the GNCTD Act as per or under clause 7 of Article 239 AA. So it's a supplemental law, not an independent law, as the Home Minister
Right.
was speaking about. It's a supplemental law. Now, a supplemental law cannot go against the provisions of that particular article. That is it. That article says that services will remain with the state.
Yes.
Services will remain with the state. A supplemental law cannot take it away.
Hmm.
Cannot say that services will remain with the center. That
Right.
is, of course, Parliament can make an independent law saying that services will remain with the union, but that is not the law which has been moved and passed by the Parliament.
Right.
The law
Right.
passed by Parliament is a supplemental law made by Parliament under clause 7 of Article 239 AA. And that makes a lot of difference.
Yes, sir. It makes a world of a difference.
Yeah, that
So
is.
the bill, sir, essentially allows the lieutenant governor to override the decision of the Council of Ministers and exercise sole discretion power over any matter, essentially. So, has the bill been, because from what I understand, the ordinance was challenged in the Supreme Court and it was referred to a larger constitution bench, in fact, to examine the Article 239 AA 7 particularly, because that aspect wasn't examined in the previous judgment. So, since that judgment is pending, what is the future of the bill essentially, as constitutionally speaking, sir? Since it has been passed on 7th of August, if I'm not wrong, by the Rajya Sabha, and but there is a judgment pending regarding that, but there's a case pending. So, how does that come into play, sir?
Oh, the bill has been passed by House, the Parliament.
Right, sir.
And after that, they can notify it and they can make it effective. So that is
Absolutely.
all.
Yes. And that
When
becomes law.
the matter is under challenge, Parliament can go ahead. Parliament doesn't stop
Yes, yes.
enacting the law merely because a matter is before the Supreme Court. When the Supreme Court decides the matter, if it goes against that, then of course the bill will go. I mean, the law will go.
So
Otherwise,
it's a
Parliament will.
constitutional effect, essentially.
Yes. No, which one?
So if it's upheld by the Supreme Court, then obviously the law it exists still. The bill is valid. But if it is repealed, or if another decision comes
No,
from the
if
Supreme,
the Supreme Court strikes it down,
right,
then that act, which was passed, giving this
effect to the bill,
revises to the central government, will go. That means it will come back
right,
to the state government. That
right, sir. No, that's fair enough, sir. What do you think are the some of the broader implications of just going over and above the Supreme Court's judgment in this manner? Does it affect other states also in a way? Because I mean, once you take out, there's a judgment. A notification comes. It's been challenged. It's been set aside. Say, for instance. then another notification comes or an ordinance comes, which is straight from the president. So what is this precedent we're setting, sir? Is this have a broader implication on the state of affairs, sir?
Yes. Number one, when the Supreme Court has given an order and a judgment, it needs to be that is the law of the land. That needs to
Absolutely.
be needs to be enforced. That is the thing. Of course, Parliament has the power to make another law changing the whole basis of the Supreme Court judgment. Parliament has the legislative power. It can do that. There is no dispute over that. But the point
Right.
is, on this issue, where the Constitution itself says that services belong to the state government,
Exactly.
then was it necessary for the Union to move a bill like this immediately to nullify the Supreme Court's verdict? Now, I'm not going to say anything about what the Supreme Court will say
Right, of
or
course, sir.
what kind of judgment the Supreme Court will give and all that. But the point is that bill which was passed and which has become the law, that bill contains many provisions uh, which are meant to nullify the Supreme Court judgment, which the union government cannot do. That is
Right, sir. Right.
now. Therefore, it is of course for the Supreme Court to finally
Decide the matter.
take
Yes,
a
sir.
view on that. Um, but what I'm saying is that when Supreme Court gives judgment on a particular issue, and here it is not that important. After all, services normally remain with the states, and without services or without having control over the services, no government can function.
Right. How do you
It's a
implement your
very,
decision
it's
then?
a very normal thing, and that
Absolutely.
is why the services have been kept under the control of the states.
Yes.
So I don't know why this has been shifted for the state. And that is an enigma, in fact.
Right. Very well said. It truly is an enigma. And let's turn our head to this another enigma, which was the unfolding of events in Maharashtra, sir. So the role of the governor, the controversial anti-defection law, the rise of mass defection raises critical questions about the political stability and also the governor's ability to act as a neutral arbiter. What are some of your takeaways from the episode that happened in Maharashtra, sir?
What happened in Maharashtra, was very kind of unfortunate, and but this is how politics operates in our country. And when the governor also becomes an active participant in the whole thing, which a governor is not supposed to do.
Absolutely.
Governor is an impartial umpire, and he, first of all, the governor doesn't have any executive power. The executive power is vested in the government,
Yes.
and the governor can set the date of the election of the speaker on the advice of the council. Governor cannot himself do that. Governor can call this session only on the request by the government, advised by the government. So there is practically nothing which the governor can do independently.
Correct.
But here, if the governor, if the governor involves himself in the political things, uh, then it becomes kind of a different situation.
Right.
And that is not actually what a governor is supposed to do. Governor has to keep away from all this. This should be left to the politicians to deal with. And if there is a problem, then it should be left to the political parties to deal with that and find a solution. That is what should be done normally. And governor should strictly confine himself to his constitutional responsibilities. But that is an ideal situation in our country, and particularly at this time, it doesn't happen.
Yes.
That so, what can one say about it? But coming to that anti-defection issue in Maharashtra, you know, there the Supreme Court also has has contributed to the confusion that
Yes.
was created there. You know, when there was defection, whether one person has defected or 50 persons have defected, that is defection.
Yes.
They have moved away from that party, and they did not merge with anybody, any party. So they were allowed to form the government. But that did not solve the problem of defection.
Correct,
That
sir.
has to be dealt with. And the Uddhav Thackeray uh, faction or the party,
Hmm.
they they filed a petition, and that was before the deputy speaker. All that the deputy speaker later was removed, and of course the speaker was appointed, and so naturally the whole thing came before the speaker.
Yes, sir.
Deputy speaker was no longer able to decide this issue.
Correct, sir. Yes.
Um, then, well, I do not want to make any comment on the political things which happened there.
Right.
And
Of
that
course.
everybody knows that I don't have to make any comment. Normally, I don't make a comment on political issues.
I
I will
understand.
confine myself to the constitutional and the legal.
Constitution. Of course, sir. That's what we're here for.
The point is, when a case goes before the speaker, because speaker is the tribunal who decides cases under anti-defection law. When this petition went before the speaker,
Yes.
uh, the other faction immediately went to, of course, they also I think moved a counter petition or something.
Yes.
But
Yes.
they
Counter
moved a
petition.
petition. They moved a petition before the election commission for recognition and symbol and all that.
Hmm. Hmm.
Um, there, the Supreme Court has uh, asked the election commission to go ahead. I mean, Supreme Court did not ask the election commission to pause and see what the speaker decides, because
Right.
anti-defection law, anti-defection law takes precedence, according to me, because it is a constitutional law.
Correct, sir.
And deciding uh, the status of a party or a faction in a party, and the symbol and that sort of and all that, that is decided under an order issued by the election commission. Election commission, that is symbols order.
Right, sir.
It is issued actually this is dealt with under the symbols order by the
Okay, sir.
election.
Okay.
On the one hand, you have a constitutional issue, constitutional law, and on the other hand, you have an issue relating to an order. So the
Right.
constitutional law should have precedence, and
Yes.
therefore, in my view, the speaker should have decided this issue in point of time. First, in point of time, because this petition was moved first, and these people went to the election commission only later. So
Subsequent.
this
Yes.
matter should have been decided by the speaker as a first issue. Now, when people move out of that party, the speaker can easily find out which party they belong to. After all, basically, that is the issue which needs to be decided. What party they belong to. If a speaker wants to disqualify a person, he has to first find out what party he belongs to.
Correct. Yes.
Now, these people, even if they moved away from the original,
Party. Yeah.
that Shiv Sena,
Hmm.
and formed a government and all that, and claimed that they are the original Shiv Sena. But then, so far as anti-defection law is concerned, you know, it is it is very clear under this law that a member's affiliation to a party is decided by which party put him up as a candidate in the election. So your party affiliation is decided on that basis. which
Right.
party put you up as a candidate in the election. So
Right.
in the election, it was actually Uddhav Thackeray's faction, party. He
Absolute.
was
Those
the
two
president
one.
at that
Yes.
time. It's they who put him up a candidate. So naturally, you belong to that party.
Right, sir.
You belong to that party.
Correct.
That is one thing, that actually should guide the speaker in deciding this matter.
I think people lost light of this fact, sir. I think nobody
Yeah,
really. People.
I do not know why the speaker also did not take notice of this or what. And it would have been easier for the speaker to decide this issue. Of course, politically, it would have been difficult.
Of
But
course. Constitutionally speaking, sir.
constitutionally, this gives you the guidance. This gives the speaker the guidance on that tricky issue. If the speakers decide that all these people belong to the Shiv Sena led by Uddhav
Political
Thackeray,
party. Yes.
the next step is very clear. That
Right.
means all of them are liable to be disqualified. So they
Correct.
defected. They defected.
As
That
simple as.
is why. That is why perhaps this issue was not allowed to be decided first. And instead, the election commission
Election.
was allowed to decide that issue, whereas
Right.
this had precedence because it is a constitutional law.
Of course. And this should have easy. Obviously should have taken
Yeah.
precedence over anything else. It's funny you mentioned that, sir, because Mr. late Mr. Atal Bihari Vajpayee, he was singularly responsible back in the day for curtailing the concept of Aya Ram Gya Ram culture of India. That because there was this famous Haryana MLA who changed his party thrice in 24 hours back in 1967. So that culture of Ayaram Gyaram was curtailed essentially by the 91st constitutional amendment that came in 2003, and which basically changed the law from one third to two-third members belonging to a political party. That was basically the anti-defection law. But the same party has found its way around it. So it's scary for a person to see what is the future of anti-defection law if it's not being followed, and being a constitutional law, that is, if it's not being followed and being put in place.
No, anti-defection law is, in my opinion, is a good law if it is allowed to be enforced properly. Now here, uh, there is a little correction which I want to suggest. For
Right,
example,
sir.
the it is actually the split provision that has been omitted from the law. Split.
Right,
One
right.
third of the members, um, if they move out and
Yes,
say
sir.
that we are a separate faction, there is
Yes,
a
sir.
split in our party and we have formed a separate faction
Of
and so
course,
on.
sir. Yes. My apologies.
They get protection. They get protection under the law. So they are not disqualified.
Right, sir.
Now, this particular provision was misused by political parties and the party breakers, They misused this provision and they circumvented it, and uh, they could defect easily to the normally it is to the ruling party, people defect to. So that was happening, and they wanted to put an end to that. That is why I think it was during Vajpayee's time that
Yes.
this amendment was brought to do away with this split provision. So after the split provision, there is only one exception remains. That is merger.
Right, sir.
Merger. It is not that one third has been converted
Okay, I
into two
understand
thirds.
now. Yes, sir.
That is not exactly what it is.
What the import was.
It is
I understand.
it's a separate provision. In fact, there were two exceptions.
Right, sir.
One was paragraph 3 and the other is paragraph 4. 3 was done away with, and now 4 remains. Only 4 remains. That
Correct.
is about the merger. Now,
Yes.
in order to take benefit of this particular paragraph, the party has to merge with another party. And the members of that party, the legislators, they will claim that our party has merged with another party,
Right.
and as a merger result of and we have agreed to that. It is not that the members will merge.
Okay, I understand, sir. They have to merge into a separate political party. Right.
Political party, this decision is taken by the political party,
Yes, sir.
not by the MLAs.
By the members. Right, sir.
So
I understand.
it is actually the political party, the original party, which has to decide whether they should merge with another party. So it's a political decision. The
Right, sir.
decision taken at the level of the political party.
I understand,
And
sir.
MLAs can only agree with that.
Hmm.
So it is not that MLAs will merge. And
And
after that,
right,
and
right,
after,
right.
after that, they will claim that we have merged. That is not
That we
how
have
it
a
is.
two party. That's not what it is. Yes.
It is the original party which has to decide to merge with another party, and the
Correct.
MLAs will agree with the merger. And those who don't agree with it, they can form a separate group and all that. So,
Hmm.
I mean,
That's
that is how it
ancillary.
is.
Yes.
So here, this has been misinterpreted by I think the Goa bench of the Bombay High Court by saying that if members, two-thirds of the members, merge with another party, then the the requirement of paragraph 2 is fulfilled.
Right.
And that was, I had written an article against that.
Right,
It
sir.
was a very wrong decision.
Hmm.
That is the thing. Because two-thirds of the members will only agree to a merger which has already taken place. So a
Right.
merger has to take place in point of time. And after that,
Step one, essentially.
the members will agree. So they will tell the speaker that we have agreed to this merger.
We have agreed to this merger. Right,
These
sir.
are the
That's
words which are used in the constitution.
right, sir.
Agreed. Not that the MLAs or MPs will merge. They have
Right.
no right to merge. Merger decision is taken by the
Political
political
party.
party. So that is the difference.
Brilliant, sir. No, thank you for really nicely elucidating that and explaining it to me, sir. Since you mentioned your article, recently I read another very nicely written, extremely nicely written article of yours, which was published on, I think, December 19th, which sheds light on a very worrying trend, sir. How governors are routinely sitting on bills passed by state legislatures, sir. This practice essentially negates the legislative powers of state and undermines the machinery altogether. There was a landmark Punjab judgment that had happened. The state of Punjab had challenged the notification, and the Supreme Court strongly came down upon it and said that one has to pass the bill or send it back, but assent has to be given essentially. So, what are some of your takeaways from that, sir?
In fact, on this issue,
Yes, sir. Sorry. Hmm.
on this issue, I have already written
Yes, sir.
article,
Yes, sir.
clarifying certain things. Article 200 makes it very clear
Yes,
that
sir.
the governor has certain options. The first point which I want to make is that when the constitution is given certain options to the governor is required to exercise one of those options and only one of those options. Now, what are these options? One option is to give assent. The other is not to give assent, withhold the assent. Third one is send it back to the assembly for reconsideration, in which case governor has to give assent. And the fourth one is sending it to the president. Of course, Supreme Court has condensed it to three. But in my view, there are four options. Anyway, but the governor can exercise any one of these options. Of course, withholding assent, is not an option now. That is not, in fact, the world over, wherever this parliamentary system is there, the power vests in the sovereign to withhold assent. Power is there. But in UK, because we have borrowed everything from UK, in UK, under their constitution, the sovereign has the power to withhold assent to a bill, but that power will be exercised only on the advice of the Council of Ministers. Now, a question will arise, under what circumstances can a Council of Ministers advise the governor to withhold assent? Because they are the ones who brought the bill before the House and got it passed, and after that they sent it to the sovereign for assent. And after that, how is it that the government, the very same Council of Ministers, is advising the sovereign to withhold assent? I mean, on the face of it, it looks a little absurd. But actually, the point is that, if the government, after sending it to the sovereign for assent, suppose the government uh, gets second thoughts
Right.
over it. And at that time, the government cannot withdraw it because it is with the sovereign.
Correct, sir.
And sovereign cannot withhold assent except on the advice of the council. That is the thing. That is the law now. Sovereign cannot give assent. I mean, withhold assent without being
Withhold
advised
assign. Yes, sir.
by the council of ministers. So the council of ministers then will advise the governor to withhold assent so that the matter is over. Government
Correct.
doesn't
Yes.
want to proceed with the law. That is the thing. That is the only situation where this can happen. But then the power should be there. Only then the sovereign can exercise this power. You know, that is why that power remains there, although it is not used except in cases where the government or the council of ministers advises the president, I mean the sovereign, to withhold assent. The second one or third one
Yes, sir.
is sending it back to the assembly.
Correct.
In fact, that is the fairest kind of option.
Most ideal way to go about it, one would say.
Ideal and reasonable, most reasonable kind of
Yes. Hmm.
option. That
Right,
is,
sir.
if governor has some doubts about a particular provision or the bill as a whole, then the governor can send a message saying that I have reservations about these provisions or I have reservations about the whole bill,
Correct.
and therefore you please reconsider it.
Hmm.
And governor can in fact suggest amendments also. And when this message goes to the assembly will immediately meet and consider the governor's suggestions. And if the assembly passes the bill in the same form in which it was passed earlier,
Right.
without any accepting governor's suggestions,
Hmm.
the governor, even then the governor will have to give assent to it. He shall not withhold assent. That is what the constitution says. That means he has to give assent.
And that's what has been reaffirmed by the Supreme Court also in its Punjab
Yes,
judgment.
yes. There the Supreme Court, has done it very brilliantly. They have they have said if the governor doesn't give assent,
Hmm.
then he has to immediately send it to the assembly. That means the
Right.
option
Yes.
of withholding assent, that has
Yes.
been
Has
knocked
been
off.
taken away in a way. Yes, sir.
That has been knocked off by the Supreme Court judgment. Now the other option, the last option is to send it to the president.
Yes.
But
That's what.
there it has become a dicey problem now,
Yes.
The because in Kerala, for example,
Yes.
the governor has kept about 8 bills or something with him for more than 2 years.
Right.
And when this happened in the Supreme Court, then suddenly he gave assent to one bill and sent all the other seven
Seven
bills
of them
to the
to the
president.
president. Right.
Now, so that raises very serious questions about what kind of bills can be referred to the president under the
President. Right.
Constitution. Constitution speaks only about one particular bill, which should be uh, referred to the president, and that is a bill which perhaps changes the powers of the or makes inroads into the powers of the High Court.
Yes. Correct. That takes away
That
certain powers or like erodes the powers. Yes.
that is the only kind of bill
Hmm.
which can be which the Constitution wants to be sent to the president. And Constitution does not say about any other bill.
Right.
But then there are two indirect references to this. One is, in Article 213,
Yes, sir.
where it says that if a bill contains the provisions which are there in the in
Yes,
the
sir.
in the ordinance, it is an ordinance making power. It is in the context of an ordinance
Okay.
that this reference has been made in Article 213. It says there also it is very vague. if a bill contains the same provisions as the
Yes.
ordinance, and the governor thinks that it is necessary to send this bill to the president, in that case, this ordinance will have to be approved by the president.
Right, sir.
Because
Because
ordinances can be generally issued by the governor,
governor, yes,
but
sir.
there are certain ordinances which can be issued only after the president clears it.
Yes, yes.
So, in that context only, the constitution says that the governor, if he thinks, if a bill which contains these provisions is going to
Contrary
be
to the ordinance.
sent to
Right,
the president,
right,
then that means such a bill can be sent to the president by the governor. And there is a certain amount of discretion which the governor can exercise, you know. That is one reference. But then there is another reference which is more, which is perhaps a little more clear. That is under Article 254. It says, if there is repugnancy, the union law will prevail. But even if there is repugnancy, if the state law has been reserved for the consideration of the president and the president has given assent,
right,
then the state law will prevail.
right, sir.
That means if there is repugnancy, the governor can send. I
To the
mean,
president.
that is what you can deduce
Right.
from this provision. So, if there is repugnancy, the governor can send that bill for the consideration of the president. So, these are the only two indirect references to bills which can be sent to the president. So, what I would suggest, what I would say from these provisions, if you can deduce a certain principle, that is, the governor can send bills which are on a concurrent list subject.
Right.
If there is repugnancy, he
Correct.
can send it. Not otherwise.
Only
Not
in case
otherwise.
of repugnancy of some
That's it.
ordinance.
Yeah.
Right.
And so far as sorry,
Of course, sir.
bills on the state subject is concerned, he cannot send it because
Right.
that is actually an encroachment on federalism. That will be an encroachment on federalism because you are bringing the president into
State
the state
affairs.
the state matters where the president has no role. The
Correct.
constitution has made this division of legislative power. Concurrent list, yes, there is concurrence jurisdiction.
Hmm.
Then there is no dispute. So if there is a dispute, naturally, the president can examine it and consider it. But if it is a matter relating to the state subject, then the president has no power to look into it. And therefore, my deduction is that the governor cannot send a bill on state matter to the president. He can send bills on concurrent subject, and that too when there is a repugnancy, not otherwise.
Or otherwise, or maybe it's a bill that's taking away certain provisions of the High Court, certain powers of the High Court,
That,
and
of course, is there in the
that's
constitution.
in the section
That
article.
that is that is not under dispute. That is there in the constitution.
Correct. So, sir, in this matter, for instance, you mentioned in your article also, and it's common knowledge that the governor of Kerala, you mentioned it right now also, that he sat on 8 bills. Then, after the Supreme Court judgment came out, sent 7 to the president, one he passed. And what do you think the future would look like if this trend continues, sir? How is this trend curbed to be curbed, sir?
Well, once it is sent to the president, it is actually the union government which decides whether these bills should be assented to by the president or not. It is not the president who decides. It is the union government. They advise the president accordingly.
Right.
But usually, you know, uh, these don't come out of the Rashtrapati Bhavan. And many of these bills, we do not know what happened to those bills. What will be the fate of those bills? There is great uncertainty about it. I don't say that they will never clear a bill, but I would say that there is great uncertainty about the whole thing.
Right, right. From the governor's aspect that we've been discussing so far, sir, Mr. Satpal Malik dissolved the governor, former governor of Kashmir, Jammu and Kashmir. He dissolved the assembly before Miss Mehbooba Mufti could prove a majority. Although he had an explanation for the same in an interview with Mr. Karan Thapar, an tell-all interview. But doesn't this fortify all that we've discussed so far about going over and above the powers that have been given to you? And what are your thoughts on that, sir?
Well, without being specific about Kashmir,
Yes, sir.
I would say that governors, of course, there have been cases where the governors, overstep their bounds and they have done things, which are not constitutionally
Right.
permissible. That has happened and that is happening. Even in these states, Tamil Nadu, Kerala, Telangana, and all that, where the action of the governors, is not strictly in accordance with the constitutional provisions. It is not a valid exercise of the power of the governor.
Right, sir.
And that is very unfortunate. Governors should actually act in accordance with, strictly in accordance with the constitution, because governors are not politicians. They are their constitutional authorities.
Correct.
They have great responsibility to see that there is good governance in the states. They should ensure that. And then there is one more thing I would say,
Yes, sir.
that a governor can caution the government. The governor can advise the government.
Yes.
Governor can very well say to the government that what you are doing is not correct.
Right.
And I would advise you to desist from that. And after that, he should leave it. He should leave it to the government, because after all, it is the government which
The
is
elected
answerable.
people. Yes, absolutely.
The government which is answerable to the people, not the
Absolutely.
governor.
Yes.
Governor is not held personally responsible for anything that he does. I mean, if he signs a particular order, which may be very unpopular and all that, but the governor is not held responsible. He is not personally responsible for whatever
Correct.
the government does. That is
Not
how it
personally
is.
responsible. Right, sir.
So he has no responsibility. He has no personal responsibility or liability
Right,
in
right.
such issues. It is actually the government. If they have done a good thing, the people will vote them. If they have
Vote
not
them
done
the
a good
next time around. That's the
thing, they will vote them
essence
out.
of. Yes, sir.
As simple as that. So the governors, therefore, should not get involved in politics. That is. But sometimes, they act more as representatives of the union government, which is led by one party, and maybe the states are run by another party government.
Yes.
So obviously there will be political rivalry and
That seems to
clashes.
be the trend, sir. If I may just
And
add here,
that has become the trend now.
a non-center party state, a
Mm.
non-majority. I mean, that is not in the center. So in those states, particularly, the bills are being withheld by the governors. That seems to be the worrying trend that has taken over, sir. So, since we've been discussing Kashmir, we touched upon Kashmir a little bit. I just wanted to bring Article 370, which is obviously, I mean, it reverberates in the political landscape because it has Jammu and Kashmir has historically moved in the opposite direction of Delhi. That's how we started our conversation, sir. As Delhi seeks to lift itself from being just a union territory to being a full-fledged state, Jammu and Kashmir was slowly cut down from the size of a super state to with so many laws that have been passed to less than state right now with the implementation of or with the coming up of the Jammu and Kashmir Reorganization Act, sir, in light of Article 3 and its provisos, What are some of your thoughts, sir? Since you mentioned Article 3 at the beginning of our conversation, sir, and I thought I'll hold this question for the end of our conversation because it's a very pertinent question, sir.
Yes, yes. I said something about Article 3 in the beginning.
Yes, sir.
But moving forward, I would say that Article 3 gives a lot of powers to the Parliament to change the boundaries of the state, name of the state, and diminish the size of the state and increase the size of the state,
Yes, sir.
and form new states and union territories and all that. But the basic question is whether Parliament has the power to convert a state to a union territory.
Absolutely.
That
Yes.
is the basic question which needs to be answered. Unfortunately, the Supreme Court did not answer that question, although that question was very, very relevant, and
Absolutely.
that should have been decided by the Supreme Court. But they left it for the future. They said some appropriate case will come and then we will decide. This was a very appropriate case,
Yes.
but it is baffling why the Supreme Court did not actually decide that issue. Now, the implication of not deciding this issue is that the government can repeat this in other states.
Yes.
What has been done to Kashmir can be done to other states also,
Any other state of India.
any other state. That is the real danger. Now, but then my point is something very basic.
Yes, sir.
So, I do a little surgery of this Article 3 and find out whether actually Parliament has this power at all, whether Article 3 gives this power. So my surgery reveals that Article 3 does not give this power to the Parliament to convert a state to a union territory.
All right,
Why
sir.
I say this? Why I say this? I say this because of two reasons,
Yes,
basically.
sir.
One is that there is no clear mention about a state being converted to union territory. Not there at all in this article.
Right.
The first part of the article says that Parliament has power, Parliament by law may
Hmm.
form a new state. A new state. Now there is an explanation where it says state means
Hmm.
state includes union territory also. So here we can say that the Parliament has the power to create a new state or a new union territory.
Correct. Okay. Because
A new,
state's definition includes
yeah,
unity.
a new state.
Hmm.
But how? By separating a portion of a state,
Hmm.
separating a portion of a state, or by joining two or more states, or separating a part of a state and making it a territory, etc., etc.
Right.
The basic point is
Yes, sir.
when when the Constitution says that Parliament has power to form a union territory, new union territory,
Yes.
by separating a portion of a state.
Correct.
Why do they say that? If the Constitution makers wanted the whole state to be converted to union territory, then
They would have
phrase,
clearly specified. Hmm.
this would not have been used.
Right.
Form a new union territory by separating a part of a state.
Right. Right.
So Article 3 says you form a union territory by separating a part of a state.
Okay.
So
Right, sir. Changes it all.
when it says that you separate a part of a state, then
Yes.
how can you say that the Constitution says that this whole state can be converted?
Can be converted. Right.
So
That's a
that is
very
my
valid
point.
argument, sir. That's a very valid argument.
That is one point.
Right, sir.
So my conclusion is that Article 3 does not provide for that. Article 3 does not confer this power on Parliament to convert a state to the whole union territory. It can create a union territory by separating a part of a state. a
So
portion
this
of a state.
Supreme Court's affirmation of Ladakh being created into a union territory, that was upheld by the Supreme Court. So
No,
that is correct then. I mean that as per
okay,
you, as per right,
okay.
that is exactly what you've explained to us today.
But I was on the point of converting a state to a union
To a
territory.
union territory altogether.
Yeah,
Denounce, I mean, make
converting
relegating
the
it to
whole
that.
state
Right, sir.
to a union territory or two union territories. One or two doesn't matter, that is not the issue. Here the point is whether Parliament has the power to convert a
Uh,
whole state
to a union.
to union territory, one, two, three, or whatever number. That is not possible
But
because it
what
says
you're saying, they can carve out a region,
a portion,
a
a
portion of
portion of a state
right,
and make it a union territory. That you can do.
right, sir.
That's
As
a
per
fact.
Article 3. So,
But
so yes, sir.
yeah,
Please go on. Please go on, sir.
but you cannot convert a whole state to a union territory. Now
Right,
the second point is that if you do that, if you concede that Parliament has this power to convert any state to a union territory, that means Parliament has power to convert all the states to union territories.
right.
Okay.
Which it does
In
not.
which case, in which case,
Hmm.
it will go against Article 1, which says that India shall be a union of
Union of
states
States.
and
Yes,
not union of union territories.
yes.
So India has to
It may
remain.
include union territories, but in
Uh,
the article it says yes.
yeah. So India has to remain as a union of states only. That is it. So long as this constitution remains in operation, then you cannot, number one, convert a whole state to a union territory. But you can create a union territory out of a state
Right,
by
right. I
separating
understand
a
that,
portion
sir.
of it. That is there. But you cannot convert the whole state to a union territory.
So what stops the central government from creating or bifurcating union territories out of every other state? I mean, they can just take 75% of Punjab and just make it into a union territory.
That, theoretically it is possible, but practically, nobody
Right.
will do that. Nobody
Right.
will do that.
I mean, one can only hope for that, sir.
There's no
Definitely,
purpose.
that's our hope.
There's no purpose. There cannot be more than, union territories more than states.
Yes, yes. That right, sir. So
India shall be a union of states only. I think.
that
And
as Article 1 nicely elucidates that India
yeah,
is a union of states.
yeah,
And
union of states.
hopefully it will remain like that.
Let's hope so.
Yes, sir. So moving on, you in our beginning of our conversation, you mentioned Article 3, which we've just discussed, as well as Article 356, sir. So, which states, I'll just read it out to you. So, that states that the president may declare that the powers of the legislature of the state shall be exercised by or under the authority of parliament. Now, petitioners in the 370 case had suggested that there is a difference between lawmaking and non lawmaking powers of the state legislature, arguing that only legislative and not constituent power is transferred to parliament under president's rule, since 356 pertains to president's rules. So the chief stated that there is no such distinction in article 356, no such distinction. And he noted that interpreting the phrase powers of the legislature to allow parliament to exercise all constitutional powers of the legislative assembly would limit the power of the state. However, he continued to state that the Constitution recognizes such reduction of federal power when the proclamation under 356 is in effect. What, as per you, is the import of this statement, sir?
Actually, I look at it, from another angle.
Yes, sir.
The If you examine that Article 356 very clearly, its clauses and all that,
Yes, sir.
the first clause says that the powers and the functions of the government and the powers which are vested in the governor shall be exercised by the president.
Yes.
Okay. In the case of state government,
Right,
functions of
sir.
the government and powers vested in the governor. Okay. So the functions and powers of a government, because governor is a part of the government, functions and powers of the government shall be taken over by the president and exercised. The president exercises those powers and functions. Okay. But when we come down to the legislature, there is one word which is missing. That is the functions. The word
Right.
functions is missing.
Right.
It mentions only powers.
Yes. Not
Only the
functions. Yes.
powers, only powers of the legislature which are taken over by the president, not
Okay,
functions.
sir.
Now, what are these powers of the legislature?
Hmm.
Powers of the legislature are two, basically. One is lawmaking. The other is voting the supply, that is money, budget, passing the
Right.
budget. These are the two powers of the legislature, any legislature.
Correct, sir.
And there are two other things. The rest are functions. There is one more thing which is very inherent in a legislature. That is punishing people who commit a breach of privilege of the House.
Right. Right, sir.
Now, coming to the functions,
Hmm.
what exactly is at issue here? That is the advisory function of the state legislature. That was the issue.
That was the issue. Yes, sir.
So whether the legislature can advise, and that legislature's advice, since the president has taken over the administration of the legislature, then the president is capable of exercising that particular function, which is not correct because the president has not taken over the functions of the legislature.
All right.
Advising, giving advisory opinion
Yes.
is only a function of the legislature.
Not power. Right.
No, it's not a part of the power.
Yes.
Power means you have to necessarily exercise it.
Correct.
But in the
This
case
is a
of
function.
functions, you may or you may not. For example, in the case of a bill for changing the name of the state or boundaries of the state, the president has to obtain an opinion from the legislature.
Correct.
But there, the president is not bound by that opinion.
Right.
Suppose the legislature thinks that it doesn't want to give any opinion. Let parliament decide whatever. If a state legislature thinks that it will not give any opinion,
Yes.
it is perfectly within its right.
Right. Okay.
That is it. So there is no mandatory provision there. There is no mandatory power there. It is a function of the legislature.
Like you nicely bifurcated it for all the viewers, sir, and for myself. That I mean, how we've been reading functions also into it, whereas it's just the powers and the functions are a separate ambit altogether.
Yes.
Right,
Because
sir.
in the first clause, both are mentioned, functions and powers.
And powers, yes.
Okay. But here, only powers have been taken over. That
Right.
is how it is. Because in the federal setup, it is actually a temporary measure. Powers of the legislature, that means passing a law and the passing of the budget. These are two most essential things
The most
which are
essential, yes,
to be
powers. Oh.
to be performed by a legislature. Now, when you are president is taking over only those things,
Right.
only the powers of the legislature, not the functions. All the functions of the legislature are not taken over by the president. That is it.
Right,
That is
sir.
why that functions have been omitted from there. And according to me, giving an advice on such a thing is a part of the function of a legislature, not a
Right. I
power.
understand that, sir. So since we talk,
Therefore,
yes, sir.
that formulation by the Supreme Court, perhaps, in my humble view, perhaps is not correct.
Right, sir.
President cannot exercise that function of the legislature, namely to give advisory opinion.
Advisory part of the legislature. Yes, sir.
That has not been taken over by the president.
Right, sir. And that's what the Constitution says. That should be the import of the article itself.
Yes.
So in the
It is
matter, yes, sir.
it is clear from the article itself.
Yes, yes.
If you read it carefully, you will find that.
Right, sir.
Well, that is my interpretation. That is how I understood it.
That's the interpretation that absolutely makes sense on the face of it, sir. And in the matter, as you said, Supreme Court did not touch upon the statehood part and of the reducing part of the
This,
center's action.
this aspect has not been explained or dealt with by the Supreme Court.
Why? Because ASG, the learned ASG, he had stated that the statehood will be restored in due course. But
Yeah.
as on date, it has not been restored. As we wrap our discussion, first of all, the picture that emerges under our federal system, India's federal system, seems to be a restrained and a considerably strained one, I would call it. And the wall separating the center and the state seems to be getting thinner by the months and by the days, and seems to be riddled with cracks and breaches. But hopefully our discussion has thrown some light on it, sir, and what all that you've said, that it's really made complete sense of all the gaps that I had, and I'm sure the viewers also must have had, on what exactly is going on and what is the state of federalism in India today. So I hope certain landmark judgments come into place. Judgments that have already been given are implemented, first of all. Hopefully, it will be that should be the case. That is the ideal case. And informed commentary and from learned people like yourself, sir, really helps rebuild the wall of federalism brick by brick. So thank you, Mr. P.D.T. Achary, sir, for joining us today and for sharing your valuable insights. Any last words for how 2024 looks like to you, sir?
2024, we are going to have the general elections and we will have a new government and all that.
Right.
So let us look forward to having a good government in place. That is what every citizen hopes for.
Yes, absolutely, sir.
Thank you.
So thank you so much for joining us once again, sir. It was an absolute pleasure hearing you talk and having this discussion with you. Thank you once again, sir.
Thank you. Thank you.
Right.